Hi, everyone, and welcome to our video legal podcast. We are very delighted to have a very interesting topic for tonight, which is myths and facts about the Surrogates Court. And a person who is an expert in the area of surrogate work is going to be our guest, and I'm so delighted to welcome Scott Kaufman.
Thank you, John. I'm delighted to be here.
Well, I am so happy. Let's start by asking the question, what is the Surrogates Court?
The Surrogates Court is a court that is tasked with the responsibility of all matters concerning decedents' estates. So if there's anything, whether it's probating a will, whether it's obtaining letters of administration where there is not a will, there are some other ancillary issues that the Surrogates Court will also have jurisdiction over, which would be guardianship, also adoption, which is similar to what the family court would do. But once there is an executor, once there is an administrator in place, the statute specifically says all matters concerning decedents' estates.
What are the type of individuals, I mean by what their background is, that work for the Surrogates Court?
Well, you're going to have a duly elected judge, which we call the surrogate, actually. The surrogate in the city of New York is elected for a term of 14 years. In the outer surrounding counties, it's a term of 10 years. But he's a state employee, the Office of Court Administration, and the unique aspect about this court than any other court is the surrogate, the judge of the Surrogates Court, is not only the judge of the substantive law, where they'll decide your motions, your litigation, or so forth, but they are also simultaneously the administrative judge of that particular court. And here in the city of New York, Bronx County, Queens, Brooklyn, where you have millions and millions of residents, those clerks who are state employees as well, those clerks could be 40, 50, 60 clerks. So it's quite the responsibility when they're elected the surrogate, as opposed to civil court or Supreme Court, and maybe you have a law secretary and a clerical staff or 3 or 4 people. You're actually running the administration of that court, which is extremely, extremely serious and a tremendous responsibility.
There are 62 counties in New York State. How many Surrogates courts are there?
Well, it's interesting, and which is that some of your larger counties, especially here in the city and surrounding ones downstate, let's say Rockland and Westchester, Nassau, Suffolk, most of them are going to have a surrogate, whereas you get to some of the less populated upstate counties, you will have a Supreme Court judge sort of serve as dual roles because you just don't have the volume that you have. And you'll have a surrogate in, let's say, Erie County and some Broome County and some of the bigger, more populated upstate counties.
How does someone with an issue get into the Surrogates Court? What are the matters that file into Surrogates?
Sure, and one of the things that we were talking about is some of the myths, and a lot of times we read about the high-profile cases of somebody having a late marriage and a contest, and the children are contesting a late will or a deathbed will. And the Surrogates Court is not just for the rich and wealthy, and it's super important that folks know that everyone has an estate. It could be small, it could be big, it could be somewhere down the middle. And in order to get into the Surrogates Court, you start the proceeding with a petition. And what's a petition? It's an ask. it's an ask. And one of the things that people talk about, and we talked about the myths, if you have a will, that will is not really your last will and testament until it's admitted to probate. And probate's literal translation would be for the truth. So you have a purported will. So you go to your lawyer and you draft out your terms of what I want, who I want to have the grandfather clock, who I want to have the house up in out in the Hamptons, whatever the devil it may be. And that is the decedent's instrument, but it's only a purported instrument until the petition asks for it to be admitted to probate and you go through the process of the courts accepting that document.
One of the issues that we hear about all the time as lawyers is statute of limitations. Does a statute of limitations play into surrogates court?
It's without getting overly complex when it comes to issues of claims and property, but if someone died 30 years ago and they owned a piece of property and there was no estate in place for them, those beneficiaries, whoever they may be, they could be grandchildren by now, you are not precluded from going into court and saying, wow, my great uncle or my grandparent died, no estate was ever filed for them, no petition was ever filed, but I need it now. Now, most surrogates court are going to say, give me an explanation in the form of an affidavit of delay. Just tell them why. Why would probably be, all the family was living there, we never thought about it, but now we want to sell. Mm-hmm. And that would be the sort of the on-point example of the delay as to why people would go later on. But you're not going to be barred from going ahead and filing for that estate.
Let's talk about something so significant with regard to surrogates, and that is a will. You made reference to it before. Let's talk, if you can, about the will.
So again, when you go to your attorney, and John, we'll get to this, but I recommend that folks don't go online and print these things themselves, that they go ahead and they see an attorney. Because one of the things that we'll probably get around to is maybe avoiding the surrogates court if you can, and you do that with an experienced attorney that will give you some options on planning. But before we get into that, so you have this document, and this document needs to be probated. The court will ask for an affidavit from the witnesses to the will, also an affidavit from the attorney that drafted the will. A lot of times, experienced attorneys will attach the affidavit to the will so that when the time comes to probate that will, they don't have to go and try to track down an attorney that might have retired 20 years ago. They'll attach that affidavit. But really the most important thing, and I think that a lot of folks, or my clients, and probably your clients as well, what they get confused about is the fact that you must obtain jurisdiction over the individuals that would take if there were no will. So just simplifying that, jurisdiction is what? It's notice. And you have to give notice to those people that would not, that would stand to inherit if there were no will. And my clients say, well, I have a will, and he, my husband didn't want to give to this child that he hasn't seen in 30 years. Why would we have to give him notice? Why would he get served with a citation? Why do we have to get jurisdiction? But the process is that those who would take, the natural heirs, have an opportunity to come in and show cause as to why they think the will may or may not be valid. And that's super important, and I can give you a context if you would like. And the, one of the examples that we give is, you had your uncle, and the uncle is not in close physical proximity, and the uncle has an aide. And what you didn't realize is that uncle's cognitive abilities started to fade. And the next thing you know that, your uncle had a will where, you were the beneficiary, your other cousins, and he might have a charity in there, and all of a sudden that uncle is dragged out to an attorney, or somebody prints out a will, and that home care attendant is now the beneficiary of his estate. So the law has a specific intent, and I hate to say the wisdom of the legislature, but sometimes they are very wise, which is that natural heir has an opportunity to come in and say, well, wait a minute, did he have the cognitive ability to make a will? B, was any undue influence exerted? Was the document a fraud? And was it executed in conformity with the law? And I could give you the simple answers. It's in order for someone to have capacity to do a will, it's a very simple test. 2 prongs. You have to know who your natural heirs are, and you have to know what you own. In terms of undue influence, the undue influence would be of physical or moral coercion, that finally what is down on paper is not what the testator wanted, but it was the person who was exerting that undue influence. And so, fraud would be that somebody else signed for them, and due execution would be the execution ceremony, which is why I always say have an attorney do it. It needs to be witnessed in front of 2 witnesses. They have to publish it. That person has to say, this is my will, and then ask the witnesses. It sounds silly, but it's a process, and it needs to be adhered to. And one of the other points that I wanted to make for some of your viewers here that might say, hey, I want to save money and print it off online or whatever, there is a presumption of regularity that attaches to an attorney-supervised document, which you don't enjoy if you've printed it off the internet. Okay. And a lot of times that could come into play.
Very important word as we talk on this subject, and that is executor.
Yes. Executor is an awesome responsibility. It's the responsibility of administering the estate. And we could certainly interchange it with the other fiduciary, who would be an administrator. Executor connotes that there is a will, whereas an administration would be there's not a will. So the natural heirs or the line of succession of who has the priority. But that executor has an awesome fiduciary responsibility to administer the estate, pay claims, collect assets, which could be selling a house, it could be getting fair market value for it, it could be paying taxes, paying your professionals, making sure that the estate is administered properly, and most important is that they have to render an accounting to those beneficiaries, and those beneficiaries will have the opportunity to say, hey, you sold the house to the neighbor next door. Why didn't you test the market? I think that you could have gotten $50,000 more for it. Mm-hmm. And the accounting is super important. If there are issues with the accounting, you could wind up having to file it rather than just trying to settle it informally. But that's where the beneficiaries would either voice an objection, say, hey, I didn't like what you did here, or you paid too much money for this, or what it might be, or might say, everything looks good, thank you, Mr. Executor, I'll sign and release you forever for it. So it is an awesome responsibility.
The executor needs to be named in the will, is that correct? And also with regard to the administrator, how is the administrator determined?
So the executor, any one of us who are professionals, we will ask our client to go ahead and nominate an executor. We'll even go one step further and we'll ask them to nominate a successor if for some reason that original executor that you nominated fails to act, doesn't want to do it, can't act because of an incapacity or death or otherwise, and you have the successor that can rise up. Some people will even go to 3 nominated executors just to make sure. And I think the choice of the executor is something that I know when I'm doing a will, we speak about in depth, and we try to envision who they're going to be dealing with. Are they properly suited? Are they going to be able to rise up to the task, understand the responsibility? So it's a very, very personal choice to go ahead and place that on someone to be that executor. For the administrator, which is the person that the decedent died without a will, there is a line of succession which gives a priority as to who has the eligibility to serve as the administrator. So if somebody was married, had a spouse, and had children, the spouse would have priority. If there were no spouse, then each of the children would have an equal priority. And it goes up the line. The statute does talk about who has the priority on that.
Another word that's important is guardianship.
Yes. Yes. And it's interesting because there's been a lot of development in the last several years with regard to guardianship. As we know that there is an interplay with the mental health law, mental hygiene law, which is Article 81 guardianship. And Article 81 guardianship is an awesome statute that helps people that can no longer take care of their affairs. However, it carries with it an awesome responsibility of accounting to the court, having your papers reviewed by the Office of the Court Examiner, and it's a whole process where in the surrogates court, a typical guardianship would be that you want to get guardianship, let's say your child, an infant, and that would be an infant under 18, right, and legal infancy, and that person, that child is inheriting funds. So a parent might say, oh, I'll just collect it for them. You might be their natural guardian, but you're not their legal guardian until you can go ahead and show that you have these letters of guardianship and say, hey, I'm entrusted with collecting funds. Or let's say it could be a step parent that wants to go ahead and consent to school trips and things of that nature. So the Article 17 of the Surrogates Court Procedure Act gives you a much easier pathway to obtaining those letters of guardianship for someone like an infant that's under 18 in the circumstance that I told you, and then also 17A, where you have a disabled child. And instead of going to Supreme Court and going through that expense, you have a child, and that child is under a developmental disability or something as defined by the statute. You can go ahead and petition the surrogates court to be that legal guardian for that disabled child who may be in excess of 18. So it gives you a real sort of expedited pathway to guardianship rather than going through Article 81.
What is the relationship between the surrogates court and overseeing adoptions?
So it's very, very similar to the family court. And a lot of times what we will do is advise our clients that if it's a simple adoption, surrogates court may be your place. If there are issues, a lot of times the family court might be better suited. But it certainly has a sort of a concurrent jurisdiction to go ahead and create that legal parent-child relationship. One of the things that we'll advise our clients is you might have a step-parent, and that step-parent has, for all intents and purposes, has acted like your natural parent for all of those years. But if there's no adoption, you have no inheritance rights to them. And a lot of times we talk about adult adoptions, which is I have a middle-aged daughter, and she's my stepdaughter, and I want to formalize that under the eyes of the law. the surrogates court is a perfect place to do an adult adoption.
How would you evaluate the notion? I mean, people are anxious to get litigation moving. Have you found the surrogates court to be a slower process than, let's say, maybe the Supreme Court?
What I will say is that, as a surrogates court practitioner, I always prefer to be in surrogates court. But B, I believe for the most part, and we have certainly, we are not in a perfect world, and here in the city of New York, there is tremendous backlogs in the post-COVID world. John, you and I know that we can wait a long time for something simple, but I will always believe that that the surrogates court is much more efficient than the Supreme Court. Okay. And I think that you have opportunities to be in front of the surrogate, and the surrogate will go ahead and get a discovery order out there, make sure people comply with it. They're very hands-on with this stuff, and for the most part here in the city, we have very conscientious surrogates that seek to move the litigation. But to that end also, one of the things that is started to rise in popularity, and a lot of the courts will actually mandate it now, is what is surrogates court if you're litigating? A lot of times it's family litigation. It's children that can't get along, or cousins, and once the parents are gone, that anchor is gone, and they're sort of ships going in all different directions. And a lot of times the court will say, is this an appropriate matter for mediation? And I always felt for many years, well, when we go to court, nothing's accomplished unless I have something hanging over your head. Mm-hmm. In the last couple of years, I've had tremendous success with clients and mediation, and the mediation program has gotten much better, and a lot of the surrogates are saying, let me send you out. Getting an experienced mediator, getting folks in a room, getting them to air out their grievances. A lot of times they want to be heard, and then say, hey, is there a common ground? And so I think that is really helping the court docket move it along. So
we have touched on a number of, I think, very key facts about the surrogates court. Let's turn to some myths about the surrogates court. And so I'll throw out one. The surrogate court is only for the wealthy.
Yes, and we touched upon it before. The surrogates court is not just for the wealthy. It's for every family that you have who owns something, a decedent that has something. In fact, there is a statute, we call it a small estate. It's now up at $50,000. And the court offers folks that are coming in, residents of that particular county, to come in, file an expedited proceeding. It may entail you have to file your will, but you don't necessarily have to probate it or go through that process if the assets are less than $50,000. And that's a tremendous advantage. And if I could just segue to a planning a little bit with it, is when folks come in and let's say they want to do wills, and let's say it would be a husband and wife, what we always talk about is setting up the estate so that you don't need the lawyer and you don't need the court, at least on the first to die. And what does that mean? That means if I have a 401k, you want to make your spouse the beneficiary, or your children. You want to put in trust beneficiary bank designations. These are called testamentary substitutes. Testamentary assets would be that would pass through the estate and pass through the will. Substitutes would be everything that would be outside. You're on my bank account. You could just go to the bank and present a death certificate, collect the asset. You don't need the court. And so we talk about if you can avoid that. Now, a lot of folks they'll go ahead, do that. They'll listen to our good counsel on that. And then it turns out they forgot to do one account, but it only has $25,000. We go do a small estate for that. So, it offers a great opportunity to do that, but the planning part of it, if people want to avoid the surrogates court, is critical. And again, go see a lawyer. Don't try to do that with online or heaven forbid AI.
How about the myth, if there's a will, you don't need a surrogates court?
Again, that is a myth. As we spoke about, a decedent will go ahead, execute a last will and testament. It might say on the top of it, last will and testament, but it is not a last will and testament until it's admitted to probate, accepted for its truth. So you will have to go to surrogates court and probate that will.
How about the myth that says surrogates court automatically takes your money?
Yeah, I think there's a lot of fear that goes on with some of that, which is, and there are some phenomenal planners that will talk about insulating your assets for Medicaid qualification purposes, or let's do a trust. Let's get the property in a trust. Let's avoid the surrogates court. And a lot of times, depending on the client, that's extremely appropriate. That can save time. That can save money. But the takeaway is not that surrogates court or the state will take that money. You'll just have to file a petition, and people do it all the time. We do it every day.
A myth says the court chooses who gets the property.
The court does not choose who gets the property. First of all, if you're a testator and you've gone to a lawyer such as yourself, or you will designate who you want to have that property, and if that will is admitted to probate, that's the law of the case that must be followed, and that property goes to that designated individual. If there is not a will, there is the laws of intestacy that will talk about who gets what. And who gets what, for example, would be the example of a spouse with children. It would be 50% to the spouse, 50% to the children, and so forth.
There's a myth that says you don't need a lawyer.
I would say that's certainly a myth. Well, you don't need a lawyer. You can go ahead and you can print a will. You can go ahead, you could file a petition on your own. In most of the courts now, they have a pro se clerk. So they will help you. I will always say that surrogates nomen example, if you had a toothache, you'd go to the dentist. And if you have a legal issue in surrogates court, go see an attorney that's experienced. In the end, it will save you time and save you money. And I would encourage folks not to be short-sighted about it. Your local bar association will always have lawyers on a referral that you could find one in your price range. And if it's something simple, you could ask them, hey, I just have a simple, who would you recommend? And you will be able to find someone that will work with you.
From your experience, are you talking about clients that are looking for or interested in surrogates? I don't know what number you want to say, 50 years and older? Do you have basically an older population that is interested and focused on a surrogates court?
Well, I think it transcends. It's always the circumstance. And I was on the phone with a colleague on the way here, and she said she's arrived at the point of her career that every call she gets, can I ask you a question? and it starts with so-and-so died, and this is the circumstance. So unfortunately, you could have young people dealing with death. You could have at any stage of anyone's life that they would have to deal with death. We would like if it was just a nice, ripe old age. And I also think that retired folks and elderly folks start to get very concerned about their estates, and they start to get very concerned about planning. They get concerned about their physical well-being, where they see themselves in 10, 15 years. Are they going to need home care? Are they going to need an assisted living? Are they going to be in a place where they need a chronic care facility? And there's all sorts of levels of planning that can deal with that, because they feel that they've worked their whole life. Number one, they'd like to stay in their home until their last breath, which is what most people want. They want to stay in their home. They don't want to lose it. They don't want to have to pay all this money for care or a facility. And a lot of folks work their whole lives, and they would love to be able to pass on something to their children and not find themselves destitute because there was a chronic, catastrophic illness. So the planning certainly is focusing in on, I think, our aged community.
What advice might you give to individuals that would be thinking about or potentially needing a surrogate's court? What advice would you give them in terms of things they should be doing or thinking about?
Well, I certainly would go back to if you have an opportunity, and it all depends on the nature of your assets, how they're held, who your intended beneficiaries are, that with an experienced attorney, you could craft an estate plan that would avoid the pitfalls of the court, or the delays, or whatever else, or sometimes the expense. And some planning can really help. I would also say that if you find yourself that you need a lawyer, you should certainly do your homework. The internet doesn't always give you the best perception of a reputable attorney, and we see a lot of stuff comes to us with, there are attorneys that kind of found themselves in the middle of a complex situation and they don't know how to get out of it, and they ask us to pick it up. Would we be interested in taking the baton from there? So do your homework, ask around. Everybody knows a professional, and although surrogate's court attorney is not something you think about every day, but you're going to know someone that's going to have a situation. Oh, I remember. I've had a case where they were sitting in their dentist chair and talking to their dentist about their mother's estate, and the dentist had said, "Well, I have a client. I just did a crown for him. I'll put you in touch with them." So it's kind of unusual, but if you do your homework and you rely on that recommendation, you should find someone experienced enough for the complexity of the problem that you may have.
You are, because of where your office is located, you are a legend, and I don't say that lightly, certainly in the Queens area. And I'm interested in, do you do any surrogate work outside of Queens?
John, I appreciate you saying that.
Well, that happens to be true, really.
I think we know each other over 30 years, and I have tremendous amount of respect for you. And your clients are doing work with you. You are the rare combination of intellect, integrity, and compassion. And so coming from you is really something I'm proud of. But I will tell you that we are in Queens County. We service most of the counties. And what we've done a lot lately is we deal with a lot of kinship issues, proving kinship where there is no will and there's not heirs that are closer than cousins, and you have to establish and go back 100 years in genealogy, and we work with professionals. So we are in the 5 counties in the city, Long Island. I have a trial in May in Erie County where I'm proving kinship. So, so we don't have a border.
I'm not surprised, and I mentioned at the outset, a very interesting area of surrogate and someone who is a super expert in it. And Scott, we thank you very, very much for taking the time to be with us today.
Absolutely my pleasure, John. Be well.
Thank you so much.